that on our stream, the judge has just walked in. Let's drop into those proceedings now.
We were, I don't know about in the middle, but taking testimony of Christopher Bloomfield. But before I have him retake the stand, is there anything we need to address before the jurors come out for the people?
Nothing, Your Honor.
And defense?
Yes, Your Honor. We're wondering if the court is going to give a written version of the jury instructions soon so we can look at that. I know we've talked about it in chambers, but we're hoping to get sort of the final set. Just with the special instructions, not all the instructions, obviously, just the ones we've been discussing.
Really, it's just one, right?
It really is just one.
Okay. Okay. So I will have my law clerk work on that while we're in here this morning. But I have it. I have it. I wrote on it, but probably can't read my writing. So what I'll do is have him amend it, and then we'll distribute it.
Okay.
Anything else before we come in?
No, thank you, Your Honor.
All right, and so I'm gonna ask the witness to retake the stand, please, that you see him in the courtroom. Would anyone like him re-sworn for today, or I can just remind you?
I have no need for re-swearing, Your Honor.
Whatever the court wants to do, Your Honor.
Okay. Sir, I'll remind you that you are still under oath from yesterday.
Yes, Your Honor.
And you may have a seat.
Thank you.
For now, until the jury comes back in, and we'll have them run their name. Welcome back. I see everyone made it back to court safely. You may be seated. Mr. Becker, you may continue with your report.
Thank you, Your Honor. I'm gonna start the morning off. You dim the lights and we need to review, please. Okay, Mr. Bloomfield, you had an opportunity to look at the video and the still frames of the video, correct?
That is correct.
For the record, this is the People's Exhibit 7, starting at frame 5592. Now, I think we left off, I just want to make sure we're on the same page. Your issue is with the taser. You didn't have a problem with the taser being used, but it was how it was, at the time it was deployed. Is that a fair assessment?
And that's a fair assessment, yes.
I'm going to show you here, kind of walking through this. Now, can you go over a little bit again, why was this bad tactics, if you will?
So 2 reasons. Number 1 is the effectiveness of the taser. In order for the taser in these situations when there's a probe deployment that is being attempted by an officer, the greatest likelihood that neuromuscular incapacitation is going to occur is when the probes have a far enough spread apart in large muscle mass areas of the body. And what TASER has also recommended through their training to officers is what they term splitting the hemispheres, where if again you use the waistline or the belt line, separating the upper from the lower hemisphere, getting a probe in the upper half and a probe in the lower half of the body, again, give officers the greatest likelihood that neuromuscular incapacitation is going to be achieved. In order for that to happen, you need to have some standoff distance so that as the probes leave the cartridge, they can have time to essentially spread apart in order to achieve that.
I'm going to show you right now, down to now 5631. I think there's a laser pointer there too. Can you give them the jury what they're looking at here in terms of where you talk about the spread and where the taser's aimed at, if you will?
So right here you can see two laser pointers which are affixed to the taser device. This is to assist officers in being able to visually see where the probes are likely to impact. The green laser dot is the upper probe or the top probe, and then the red dot is the lower probe. Again, and they're different colors so that officers are best able to distinguish between the two. And again, so that's a visual indicator. So right here you can see that both of the probes, based upon the laser sighting, are above Mr. Loya's belt line. And so that would indicate to an officer that both of those darts are likely to go just in the upper hemisphere.
What was the other issue then that you had in terms of with this opponent? It's not just the taser distance, but it was something else related to weapon retention?
Correct. So it's generally accepted in policing all across the country. The principle of what we refer to as weapon retention, where officers are taught tactics to retain their weapons, essentially to keep other persons from grabbing and getting a hold of their weapons and potentially using those weapons against either the officer or other bystanders. So this is a heavy part primarily of defensive tactics training that officers go through. Both the basic training as well as they go through refresher trainings throughout their career. And so extending a tool in close proximity to an individual, especially one that is facing you in this manner, creates a high likelihood that your weapon is likely to be grabbed, or your tool is likely to be grabbed in this particular instance. What we see a lot of times, and again, this is not just related to tasers, this could be firearms, batons, OC spray, is that when it's in close proximity, you will have subjects who will reach out and attempt to either deflect or disarm officers just because the opportunity is there, even if prior to that there was no indication that an individual was attempting to close distance and disarm an officer. It's more opportunistic in a lot of these cases.
And so that's what essentially happened here, because you continue on. The weapon is grabbed right around 56, 58. And then 56, 70, you clearly see the taser in the hand of Patrick, correct?
That is correct.
Now, you didn't just look at this frame by frame, you looked at all the videos, correct?
All the videos were provided to me, yes.
Take it, this is going to exhibit 1, the cell phone video.
Okay, why you got
For the record, it's about 50 seconds into exhibit 1, Your Honor. What did you hear there?
So what I heard there was what I would recognize as being consistent with the sound that a taser makes during a probe deployment. So you initially hear a pop, which is essentially when the cartridge, or excuse me, when the probes are leaving the cartridge of the taser, you'll get that distinct popping sound that you hear, followed by the cycling of the taser, which is consistent with kind of what I consider kind of an electrical sound or an electrical cycle.
Continue on with the
okay, why you gotta do all that, bro? He good, man. Let's call it taser. Let's call it taser. No, he good.
So did you hear anything there?
Again, at this point, I heard another popping sound that I recognize as being consistent with a probe deployment.
And just for the record, that's about 113 in Exhibit 1, Your Honor.
Hey, you can talk to him, bro. Ah! Yeah, damn. Like he good, bro. Like, can you talk to him like good? Like, can you, yeah. Stop grabbing him like that. Now he good like for real. Yo, you hit him too. He's that shit. Don't call the taser! Now he ain't brought no taser. I see that. Let go the taser! Drop taser!
I'm going to stop right there. Now, in terms of, did you ever hear any additional taser deployments other than the two you just mentioned?
No, I only heard the two. The other thing that I wanted to mention, just because you asked me about sounds, is with each taser deployment, you'll also hear kind of a chirping or a beeping coming from the taser. These tasers, specifically this model, has built into its software to where it will cycle for 5 seconds automatically, then it has an automatic shut off. And so that chirping is notifying the officer that, hey, this cycle is coming to an end. And in both probe deployments, or what I recognize to be the sound of probe deployments as was asked, you also hear the follow-up chirping notifying the officer that, hey, this 5 second cycle that is active is about to come to an end.
And that was kind of my next question. Did you ever hear that chirping at any point in time after that? Other than the two deployments, did you ever hear it, at this point in time or just before the shooting?
No.
So obviously you took a look, you saw the shooting now, you've seen this whole incident in your analysis of this case, correct?
Yes.
Could you tell the jury what your opinion is when a reasonable officer in the same circumstances made the decision to fire, as we just saw?
So with the taser, there's a theory that's commonly held within the policing industry with regard to an officer being disarmed of a taser. The theory essentially posits that an officer may be justified in using deadly force if they were disarmed of their taser because of a threat that they may have the taser used against them, specifically being incapacitated by the taser. In order for that to be a valid claim, the taser would have to be in a condition to where it could cause neuromuscular incapacitation. The greatest likelihood of neuromuscular incapacitation being achieved, as I've mentioned here on the stand multiple times, is through a probe deployment. The Taser 7 is equipped with two cartridges, and those cartridges are there because, again, over the years, the original tasers only had one cartridge. Then Taser started coming out, Axon started coming out with multi-cartridge models because, again, a lot of things have to go right in order for to have a good probe deployment and have neuromuscular incapacitation achieved. And so Taser started again coming out with multi-cartridge models to give officers follow-up opportunities in the event that they were unable or unsuccessful. And so there's only two cartridges available. Beyond that, when it comes to drive stun mode, even with the expanded cartridges, we're now in a situation where the taser can still be used in follow-up or drive stun mode, but that operates off the principle of pain compliance, so it does not achieve incapacitation. And so in this particular circumstance, you have a situation where a taser is no longer in a condition to where neuromuscular incapacitation is likely to be achieved, either against the suspect or against the officer in this particular case. And so based upon that, a reasonable officer in this position to elect to use deadly force, knowing that is the condition of the taser, that would be unreasonable, excessive, and contrary to generally accepted police practices.
I have no further questions, Your Honor. Thank you.
Mr. Bloomfield.
Good morning.
Okay. I'd like to ask you a couple of questions about your background.
Yes,
I think you said you work for a hospital system or a hospital
I
chain?
do now, yes.
And what do you do there?
I'm the regulatory manager.
Okay. What do you do as the regulatory manager?
So I'm responsible for making sure that the organization which I'm employed with is in compliance with federal and state regulations. Primarily, the regulatory body in healthcare is CMS, Center for Medicare and Medicaid Services, and so they set standards the hospitals must comply with in order to qualify for those monies.
Do you ever review situations to determine whether or not a particular situation, individuals comply with regulations or rules?
Yes, I do.
Okay. All right. And I'd like to talk about, really, you gave focus really on two opinions. One was yesterday, and you had a little bit of that today. And then you had another opinion, the one you just ended with, and I'm going to talk about those in order.
Okay.
Okay, so now you did team up with Professor Stoughton in this case, correct?
Yes, I did.
And so you guys have a joint report.
Yes, we do.
All right. How do you know Professor Stoughton?
So Professor Stoughton now is a colleague of mine. When I was conducting research for our organization, when I was employed with the Farmington Police Department in reference to contagious fire phenomenon, he was one of the academics that I reached out to, and we began a rapport from there, and then that turned into some professional teaming up and working in this field.
Okay. All right. Thank you. So yesterday you talked about OC spray.
I did.
Can you tell us if OC stands for something?
It does. It stands for oleoresin capsicum.
Now we know why they call it OC spray.
That's correct.
Okay. What is the purpose? Is it something that a police officer might have on his or her belt?
Generally speaking, yes, and so OC spray is a common force option that officers are provided that is very common throughout the industry.
You wouldn't classify it as a deadly force?
No, I would not.
Okay. Now, you were talking about it, but is anything in your opinions, or is it your opinion that because Officer Schurr didn't use OC spray, he acted unreasonably?
No, not in this particular case. Part of the use of force calculus is what reasonable options did an officer have. That clearly could have been an option that would have been reasonable based upon the level of resistance that a reasonable officer in this situation would have observed. But it didn't. It wasn't selected as an option in this case.
Okay. All right, and if we could switch over to the defense and 5400, RFN 5400 from Defense Exhibit A. So I'm going to play you the part about the taser and
Okay.
before the final use of deadly force. And it's not very long. No, we have a spot, I'm sorry, we have a spot over there. The plug's got to be connected.
There, it goes green now.
And so this is with regard to the opinion that you finished up today, the taser deployment, the first one. If we could just play that in normal speed. And this is RFN 5400.
Let go of the taser.
Yeah, that's good. Okay. And so when you're talking about Officer Schurr's use of the taser, you're talking about those seconds in that video.
Yes.
And so you would agree that this happened over the course of the reaching for the taser was a matter of seconds.
I would agree with that.
Okay. And it's your opinion that using the taser in that situation is fine, but it's the manner in which you used it was not fine.
That is correct. The taser as a force option was reasonable. However, the manner in which it was deployed was tactically unsound.
And part of that is because of the distance, and because you didn't believe that there was the ability for NMI at that distance, correct?
Not the ability, but the likelihood, based off manufacturer recommendations, that NMI could be achieved was significantly diminished.
Okay, and I think you said yesterday that the preferred range is 7 yards. Did you mean feet?
No, feet.
Okay.
Yeah, sorry if
I
I
thought- I didn't think you
misspoke.
meant
So-
21 feet, but.
No.
You know, we did make you testify right after getting on
Yes.
off the plane. So, all right, so 7 yards, you believe is the preferred range, so you get 12 inches? Or 7 feet? Did I just
Yeah,
say
7
yards?
feet, you
I'm
did.
sorry.
I was going to correct you, but you're fine. So, yeah, no,
Please
you're
correct
good.
me if I do something
No,
like that.
you're good.
Okay. So 7 feet would allow you to get 12 inches of NMI.
Generally, of spread, generally speaking, but in addition to that, TASER recommends that those probes split the hemisphere, so you have, yes, one probe, just as you're demonstrating, one above the waistline, one below the waistline.
And it's your opinion that this isn't close enough to split the waistline? I mean, it seems like he's pretty close. He's just above the belt buckle, right?
Again, I'm speaking, it's close, but however, I'm speaking to TASER's recommendations, so.
Okay, and with regard to those recommendations, with the TASER 7, the actual recommendation to get the 12-inch spread is 4 feet, right?
Is what,
4 feet?
4 feet?
Yes.
Could be.
Okay, so it's
Yeah,
not
yeah,
7.
I don't recall specific, 4 to 7, somewhere in that range. There's not, yes, I'd leave it at that. So I don't have the materials directly in front of me.
Well, and in your report, you say 7 feet as well.
Yes.
And you're basing that on the trainings that you reference in your report, right?
Yes, so TASER does provide trainings to departments. Anytime officers undergo TASER training, they actually do not, they may have their additional curriculum, but TASER actually provides a curriculum for officers that they recognize as the curriculum that officers essentially would need to go through for the manufacturer to recognize them as a valid operator with their device. And again, they put that out, and so certified TASER instructors have that. All the information that I referenced in the report, so if it was 7 feet in the report, that would come directly from TASER.
Okay, and you're referring to particular trainings on the TASER 2, right? In your report?
I don't recall specifically, does it stay in the report?
Have you ever worked at Axon?
No, I have not.
Okay. Okay, now, in a close proximity situation, let's say you don't get the full 12 inches. Are there any departments that train that you can use the drive stun to complete a circuit of more than 12 inches?
Yes,
So if one probe goes in and another one misses, right, and sometimes that happens, right?
yes,
You can just make a
more
third
often than
point.
not.
What's that?
Said more often than not,
And because you have two darts basically going on, and they're designed to actually spread distance, right?
correct.
So you can make the third point and cause NMI.
Yes, you could.
Okay. Okay, and then I think you testified that in this situation, he should have created more distance, preferably 7 feet, according to you, right?
At least enough distance in order to get a reasonable spread that would split the hemispheres.
Okay. But there are some situations where officers really can't create distance, right?
That is correct.
And one is if you're in a confined space,
Correct,
there's nothing you can do. You can't go through a wall.
correct.
But that's not the case here.
No,
They're outside. And also when a suspect is closing in on the officer, right?
Yes.
Okay. And is it your opinion that Mr. Leolia wasn't closing in on Officer Schurr at all?
Correct. In the video that we reviewed, the one that's been shown here today, you can see that Mr. Leoia's posture is always trying to create distance from the officer, and the officer in this case is the one who is closing the distance.
How about when Mr. Leolia grabs the taser? That's not closing the distance?
At that moment, Mr. Leoia, at that moment in time when the taser was presented, reaching forward, I wouldn't necessarily constitute is closing the distance. He's reaching forward to grab the taser. I would agree with that. But the whole reason why that opportunity even occurred was because the officer in this case is the one who closed the distance on Leoia, who was trying to create distance from the officer.
He didn't give him the taser though, right, the officer?
No.
Okay. Mr. Leolia grabs the taser.
Correct.
Is reaching out to grab something off an officer an act of aggression?
It could be. It's also consistent again where individuals are simply trying to defend themselves from being, in this case, having a taser used against them, being shot. There's a number of reasons, and I don't know the mind of Mr. Leoia.
Well, just based on the video,
Mm-hmm.
you agree that it could be an act of aggression for someone to grab a taser from a police
Correct. It
officer.
could also be an act of defense. Yes.
Okay, and an act of defense like deflecting something, right?
Yes.
Okay, how about disarming a police officer? Is that an act of aggression, in your opinion?
Yes.
Okay. Now, you and Professor Stoughton had some opinions about things that happened more than a minute and a half before deadly force was used, like chasing Mr. Leolia around the car.
Yes.
And you talked a little bit about it yesterday, and Professor Stoughton talked a lot about it. Is the fact that, in your opinion, Officer Schurr shouldn't have, it was unreasonable for him to chase Mr. Leolia? Does that mean that he no longer can use deadly force at a later time?
No.
Okay, so he's still, if he's reasonably in fear of great bodily harm or death, he can, or if someone's going to attack him, if he's reasonably fair, he can still use deadly force, right?
So I'm going to clarify just a little bit. In order for an officer to be justified in the application of deadly force, they must be able to articulate why they have a reasonable belief that they themselves or another individual is under immediate threat of receiving great bodily harm, great bodily injury, and or death. by the
That's
actions
generally
of
accepted
another.
police practices, right?
And that is the language the Supreme Court uses, which is what was adopted by the policing industry and has now become generally accepted police practice.
And to be clear, you're talking about the U.S. Supreme Court,
And that is correct.
not the Michigan Supreme Court.
And that is correct.
Okay, because you're not familiar with Michigan law.
I'm not.
Okay. All right, and then you talked about Officer Schurr's use of deadly force. You say it's unreasonable and contrary to generally accepted police practices.
Yes.
And I understand that the basis for your opinion is that the taser wasn't in a condition to incapacitate him.
That is part of the reasoning, yes.
All right. And I think you testified about it. You can hear the pop, right?
Yes.
Okay, and you know that there's two probes, right?
Yes.
Okay. Now in, I believe you testified about, it's generally accepted that in the absence of physical ability to incapacitate the officer, or otherwise render him unable to protect himself, no reasonable officer, not one, could have concluded that Mr. Lillia presented a threat of death or great bodily harm. That's what your opinion is?
Under this specific case, a specific fact pattern, yes.
Okay. And the reason you're forming this opinion is because you know that if an officer is incapacitated, he's lost the ability to protect himself, right?
That is the theory, yes.
Okay. And we're talking about what he reasonably believed in that situation, right?
Not what he reasonably believed, what a reasonable officer would have concluded.
Okay. So you're just talking about objectively reasonable officer standard.
That is the standard, the only standard in the review of all cases that's accepted in the industry.
Okay. Generally accepted.
Yes.
Not talking about Michigan law now, right?
Not talking about Michigan law.
Okay. So you don't consider whether or not the arresting officer, in this case Officer Schurr, knew that the second probe?
So when we review cases, we do take into account the subjective statements, opinions of officers, as far as to fill in what a reasonable officer in that officer's situation would have known at the time.
Did you review Officer Schur's statement in this case?
We did.
Okay. And in there it said that he,
Jack, this is hearsay, you can't get it in, I can get it in if I want to, it's the same against party opponent, he can't get it in.
I believe the expert relied on it in his opinion, so I'd like to ask him about that.
Well, you can't, doesn't make hearsay admissible, so.
Well, there's a lot of what hearsay that he's talking
That's
about.
what he based it on, but you can't say, my client said, whatever he said, that it would be hearsay. So I'll sustain the objection on that basis.
Mr. Bloomfield, you relied on a lot of materials, including training materials, right?
We did rely on some of the training materials that were provided, yes.
And you said you considered the statement as well when forming your opinion?
Yes, we did.
Okay. So I believe you testified yesterday about incidents where if an officer is incapacitated and loses his firearm, he can be shot or killed, right?
I don't recall getting into that yesterday. I did touch on that briefly today.
Okay. Are you aware of situations where an officer is incapacitated and then loses his firearm and is shot and or killed?
So I need a little clarification there. When you say incapacitated, are you talking incapacitated with a taser specifically or incapacitated by other means?
Well, let's talk about both.
Okay.
Okay. Incapacitated by any means. Are you aware of any situation where an officer's been killed after being incapacitated?
Yes, there are situations where I would personally classify that an officer's been incapacitated. Maybe that would mean being knocked out, being injured to a point where they're no longer able to successfully defend against somebody disarming them. I am aware of incidents like that. Okay.
And here, the concern is, with a taser, you could be incapacitated if NMI occurs, right?
Yes.
Okay. Are you aware of incidents where an officer has been tased and has been shot?
Where an officer has been tased and then shot. It's a very specific circumstance. Right now, I'm not aware of anything. Myself and my colleague, Professor Stoughton, him specifically, conducted extensive research on officers killed in the line of duty, and we are not aware of any case or instance where an officer had a taser that was used against them where they were incapacitated, and also within that same set of circumstances, it resulted in an officer's death where they were disarmed. In addition to that, I do not know of any case, not including deadly force, where officers have been disarmed of their tasers, where an officer has been successfully incapacitated by a suspect.
You're not aware of that, right?
I'm not aware of that, and nor in any of the research that we conducted in preparation for this did we ever find anything that would or that would essentially change my opinion. If I was aware of at least an instance, I would let you know.
Okay. I'm just asking you about what you're aware of and what you relied upon. Now, your opinion states that it's unreasonable for Officer Schurr to believe he could be incapacitated, right?
For an officer, yes, in his circumstances.
Because the available evidence establishes that any reasonable officer in Officer Schurr's position would have been aware that Mr. Leolia did not have the ability to incapacitate Officer Schurr because both of the cartridges in Officer's taser had been discharged. Is that right?
Yes.
Okay. So it's unreasonable for Officer Schurr not to have known that the second cartridge had been discharged?
I believe what we state in our opinion is that an officer in these circumstances would have known that both cartridges had been discharged from the taser.
Okay. And because you assume he would have known, he is therefore unreasonably believing he could be incapacitated by the taser.
Correct.
You also have stated that in stressful environments, human decision-making suffers. Officers may experience distorted sensory perceptions, including visual distortions, like tunnel vision, auditory distortions, which is auditory blunting, and temporal distortions, perceiving events as occurring more quickly or more slowly than they actually are. Is that a
Yes.
fair statement?
Yes, it is.
In fact, you said it, right?
Mhm.
Yes?
Yes.
Okay, so what, you talked about auditory distortions there, for example, auditory blunting. What's auditory blunting?
So, again, it is a term that is known in the industry. Auditory blunting or auditory exclusion is what they're most commonly referred to. So essentially, that is a phenomenon, physiological, psychological phenomenon, where under stress, when officers have discharged their weapons, they report that essentially the signature of the weapon being fired, the sound, is reduced. And that has led officers to believe that in some cases that something is wrong with their weapon as a result of that. And so, again, this is a pretty well-known phenomenon. Most officers receive education that if they are involved in a deadly force encounter and they discharge their weapon, that a lot of these physiological and psychological phenomenon may be experienced. Auditory exclusion happens to be one of the most commonly reported phenomenon that is experienced along with tunnel vision.
And what's tunnel vision?
Tunnel vision is essentially where officers, and again, this doesn't just have to be officers, it could be soldiers, but in deadly force encounters, they become hyper-focused. Essentially, their vision, they report what could be termed as superhuman vision, where they're able to hyper-focus, mostly on weapons. At far distances, officers have reported being able to see amazing things. Also time distortion, where generally speaking, among most officers in deadly force encounters, they report time as if it's slowed down for them. Rarely do we hear any reports of time speeding up, some, but mostly time is slowed down.
Okay, and these phenomena occur in stressful environments.
They can. Their most common reference is in when officers are actually under the threat of receiving great bodily harm, great bodily injury, and or death, and responding to that threat, primarily with deadly force. And so it's just not all stressful situations. In general, officers encounter stressful situations all the time. The majority of the literature and the research is specifically around deadly force encounters, specifically when officers are under the threat again of great bodily harm, great bodily injury, and or death, and are responding to that threat to defend themselves.
Is the video that you just saw one of those types of stressful situations where auditory blunting could occur?
Generally, the situation is pretty common in policing in terms of the events that transpired. As far as Now, when you said that statement, and correct me if I'm wrong, is it possible, if you're saying is it possible, well, I'd have to concede that anything is possible. Is it plausible? No, and the reason why I say that is because there's nothing in this situation that I would term that an officer in these circumstances would have a reasonable belief that they were under immediate threat of receiving great bodily harm, great bodily injury, and or death.
Well, we just talked about the fact that you had formed an opinion
Yes,
that if Officer Schurr had been incapacitated, he could be harmed or die.
yes,
And then you gave us your opinion that he wasn't in the situation because he didn't hear the second probe, right?
state that one more time.
Well, let me ask this a different way. Are you an expert in auditory exclusion?
I am not.
Okay. All right, so we talked about incapacitation. What you don't talk about is whether or not do you have an opinion on whether or not the drive stun can cause bodily harm in a situation where a person has taken an officer's taser, as in within a foot or two of the officer?
So when you say bodily harm, can you give me a reference by what you mean with bodily harm?
Like being blinded or getting hit in the throat and the trachea collapses.
I would assume that those things could be possible with that
Okay.
taser and drive stun.
Okay, so in a situation such as this, where the taser is close to the officer, is it reasonable for him to fear that he could be harmed in those ways, given the situation?
Again, it's possible, but anything is possible. I didn't see anything in the facts of this particular case that would lead me to believe that a reasonable officer would have felt that that was an immediate threat at the time deadly force was applied.
Well, Mr. Leolia in this case had switched the taser from his left to his right hand. You're aware of that, right?
Yes,
Okay. And he had it in exclusive control over it in his right hand, right?
when you say, again, exclusive control, I don't know what you mean by that. His hand was on the taser. He never had his hand in what I would term as fire control, or in the way that an individual would commonly hold it to activate it to cause either drive stun in this case with the condition the taser was in.
Would that make a difference to you if Mr. Leolia was holding it like a gun? Would that change your opinion?
It would influence my opinion. I've had cases where that has been the circumstances.
One moment, Your Honor. Nothing further, thank you, Your Honor.
You kind of right to the one opinion. You said, one of his questions was that, well, your opinion is based on the taser's not in a condition to incapacitate him. And you said, well, that's part of my opinion why the use of force is not appropriate here. What's the other part, I guess? What is missing out of that opinion? It's not just the taser, what else is there?
So when we talk about any application of force within policing, it's based upon a number of factors. One is proportionality to the resistance or threat that an officer perceives. During this entire instance, while I talked about the other applications of force that a reasonable officer would have used throughout this situation as it unfolded, the primary form of resistance that was demonstrated by Patrick Leoya would be classified as resistance. And so resistance in the form of physical resistance, attempting to get away, being taken into custody, creating distance. Not at any time in any of the evidence that we reviewed did we ever see Patrick Leoya attempt to harm the officer in this particular instance. As noted, Patrick Luoya did grab a hold of the officer's taser, and there was a struggle over the taser in this instance. But again, in this circumstance, it is that there was nothing that we term to be aggressiveness or combativeness on the part of Mr. Luoya towards the officer in this case, coupled with the fact that the taser is not in a condition where neuromuscular incapacitation could be achieved, in addition to the fact that a reasonable officer would have known that that was the condition of the taser. And so all of those things together would lead a reasonable officer to conclude that they do not have grounds to reasonably articulate that they were under an immediate threat of receiving great bodily harm, great bodily injury, and or death. Therefore, that classifies the application of deadly force in this instance as unreasonable and excessive.
Thank you. I don't think further. You have a couple more questions, right? On that?
Mr. Bloomfield, does an officer have to wait to be harmed before he acts?
They do not.
Okay. And it's your opinion that you never saw any act of aggression by Mr. Luoya on those videos?
No.
That's not your opinion, or you didn't see any?
My opinion is that we did not see any actions by Mr. Luoya that we would constitute as active aggression attempting to harm the officer.
Okay.
Yes.
Yes,
I have nothing further, Your Honor.
And I do see one hand raised on the jury, so I'll have my clerk come and grab that question from you. Right now, hold it, please. So I'm gonna pass the question back because there's one word that I'm trying to make it out, I just can't. So I'm gonna ask if you can just rewrite it, and I just noted which word it was. And then, I'll have you approach. Find errors on the other's choices of force or lack thereof.
I don't know if I'm fully or can grasp what the question is that the jury needs assistance with. Can you read it one more time, Your Honor, and I'll.
When investigating cases, do you usually find errors on the other's choices of force or lack thereof?
So, when investigating these types of cases, I think if I'm understanding the question correctly, the question is do we often see errors on the part of officers in their decision-making and, the levels of force that they choose to employ? The answer would be yes and no. in a number of cases that myself and my colleague in this case, Professor Stoen, we basically review, hundreds of cases. And in cases, we find where the actions of the officers are completely reasonable and consistent with generally accepted police practice. In other cases, we find the opposite, where none of the actions of the officer were reasonable and consistent, and then we find a mix, where sometimes some of the actions of the officers were reasonable and other actions were not reasonable. In this particular case, we rendered a number of opinions on the actions of a reasonable officer in these circumstances that we found to be reasonable. Most of that was leading up to the deployment of the taser. We said, hey, we recognize that the majority of these decisions by a reasonable officer in this case were reasonable decisions and were consistent with generally accepted practice. And so I hope that answers the question.
I have no follow-up, Your Honor.
No, Your Honor.
I don't see any other hands raised on the jury. May this witness be excused?
Me, Your Honor.
Any objection? Thank you very much.
Thank
sir.
you, Your Honor.